Thank you, Mr Gray, and I beg to move that this House has considered the subject of British property owners in Cyprus, and it's a pleasure to see you in the chair. I'm grateful for the chance to raise this issue on the floor of Westminster Hall. I'm not the first member to take this up on behalf of our constituents, and I'd like to begin by praising the work of the all-party parliamentary group for the defence of the interests of British property owners in Cyprus. Under the chairmanship of the Honourable Member for Stone, this group has done great work in raising the concerns of people caught up in property and banking problems in Cyprus, and has provided a framework through which to pursue justice and fairness in relation to their properties. Now, I've been contacted by a number of people in my constituency about the mis-selling of Swiss Franc mortgages by Alpha Bank in Cyprus, and poor advice received from solicitors purporting to be acting on their behalf. The brief background to this issue is that between 2003 and 2010, Cypriot banks advised buyers to take out a mortgage in Swiss francs because the interest rates were lower and the currency was considered stable. However, when the value of the Swiss franc soared against the euro in the aftermath of the financial crisis, buyers found that their mortgage repayments had doubled. Buyers have complained that banks often failed to explain the potential risks and that currency fluctuations could cause repayments to rise, which has resulted in property owners being left with unfinished and unsaleable apartments, huge loan obligations and negative equity following the collapse of the Cypriot property market, which saw property values in some areas plummet by as much as 70%. In one case brought to me by a constituent, the developer went into liquidation before the property being built for him and for his wife had been completed, taking 85% of the mortgage fund and leaving insufficient funds to finish the remaining work. My constituent says that his solicitor and Alpha Bank allowed this to happen by permitting the developer to sign written confirmation himself that the various stages of work had been completed. They had to begin making mortgage repayments at a time when they did not have the land in their name and the property was not finished. So effectively they were paying a mortgage on a property and land that was not legally theirs. When they explained to Alpha Bank that they were in a desperate situation, they were simply told that if they didn't make their mortgage payments, the bank would seek possession of their home here in the United Kingdom. Similarly, another constituent with the same Swiss franc mortgage with Alpha Bank spoke of what he believed to be collusion between the bank, the solicitor and the developer, leaving him threatened with bankruptcy. Now, I'm sure that these examples will be depressingly familiar to anyone who's had dealings with people caught up in this fiasco. I will give way.
All-party group for the defence of the interests of British property owners in Cyprus. I know that the Honourable Member is a member of that group. Is he aware that we're going to be having a meeting on at 11 a.m. on the 12th of November of those affected, at which the High Commissioner for Cyprus, Mr. Evrivardis, will be present, and that there is a bill that's currently being before the Cyprus Parliament, which I'm sure he'll be dealing with shortly, so I won't go into any more than that.
No, I'm very grateful for the Honourable Gentleman's intervention, and he's absolutely right. And I commend him for the work that he's done in leading that all-party group. And it is my intention, should parliamentary duties permit, for me to be at that meeting, or certainly a representative from my office to be there if I'm not able to be there. And I am aware of the situation in Cyprus. Mr Gray, there have also been allegations of Cypriot solicitors using invalid powers of attorney. The case I want to focus on specifically today, on behalf of one of my constituents, is an example of that and goes on to highlight his concern about his legal representation as he seeks to obtain redress. I will give way.
Before my humble friend moves into this specific case. I've had conversations with a number of leading politicians in Cyprus and found them very sympathetic and understanding of some of the problems my honourable friend refers to, and I congratulate him on getting this debate. I just wonder if when the Minister responds, if he could let us know whether he's had conversations with members of Parliament in Cyprus on this matter.
My honourable friend is absolutely right to raise that point, and I would expect and hope that the Minister in his concluding remarks will be able to answer that, because I think it's very important that whatever pressure can be brought on the Cypriot authorities by Her Majesty's government in the United Kingdom, that they do, ministers do all that they can to raise this issue with their Cypriot counterparts. I will.
The Minister for Europe has been immensely helpful. He has actually been to 2 or maybe even 3 meetings which I've convened for the purpose, and I just want to pay tribute to him for the active interest that he's taken in this.
And the honourable gentleman's absolutely right to highlight the work that the Minister has done and will continue to do in respect of the injustices that many of our constituents are facing, and I look forward to the Minister's reply. Now, Mr Gray, my constituent does not want to be publicly named, so I will refer to him throughout as Mr TC. In 2007, Mr TC and his brother-in-law wanted to purchase a retirement property in Cyprus through a UK company called ROPUK. They met with their representatives who showed them impressive brochures and projections, and they decided to go ahead with the purchase. They paid a deposit of £25,000 and understood that when the property was built, they would go to Cyprus to have an inspection and then sign a mortgage agreement. They were advised by ROPUK's representative that a Swiss franc mortgage would be best, but they did not sign up to any agreement except to give a Cypriot solicitor power of attorney in any transactions that they agreed to. In 2010, when the property was due for completion, Mr TC visited Cyprus to monitor the progress of the build. He found that it wasn't even half finished, and it's still the same today. He believes that the power of attorney was not executed in accordance with the common or Cypriot law, therefore rendering it illegal and anything signed using the power of attorney invalid. They first heard of Alpha Bank when they started to pursue them for payments. They did not personally sign any mortgage agreement. It was signed by a third party without their knowledge or consent, and they have never even seen the mortgage agreement with Alpha Bank, despite repeated requests to do so. They believe that the bank, in effect, released all of the money from their fraudulently obtained mortgage agreement to fund something that is simply not there. The payments from this mythical mortgage should have been gradually dispersed as the build progressed, according to the progress certificates issued by the architect of this project. The bank surveyor should have been inspecting the development and issuing a report back to the bank, a copy of which should have been passed to the Cypriot solicitor, who was supposed to be acting in their best interests, to verify build stage against the drawdown of money. I will give way.
Very briefly, just to say that under the bill to which I just referred, the new law gives the Republic of Cyprus Land Registry the authority to exempt, eliminate, transfer and cancel mortgages and encumbrances depending on the case and under certain conditions. I haven't time to go into all the details, but I just want for the record to get that on the in Hansard.
No, I'm very grateful, and it's important that that fact is placed on the record. Mr Gray, coming back to my constituent's specific case, none of this was ever done, which is why years after supposed completion, they still have absolutely nothing. They now owed the bank in the region of £257,000 plus interest. The original price that they were quoted was around £140,000 minus their deposit, and they were issued with a writ. They were informed that their case would be heard in the Courts of Justice in London in June 2014. They received the writ less than a week before the case was due to be heard, and they had no time to appoint a solicitor. The case was heard at the Courts of Justice in front of Master Easton. He asked Alpha Bank solicitors Stevenson Harwood to shelve the European enforcement order pending ongoing legal discussions in Cyprus, and they refused. A European enforcement order was rubber-stamped, subject to a second hearing in September. By this time, they'd appointed Cubism Law to represent them in the second hearing, and their case was led by Duncan McNair, who they understood to be an expert in this field. The representation that they had in the UK forms the second part of the concerns raised with me by Mr. TC, because he and his brother-in-law paid Cubism Law £2,000 up front to represent them. A barrister attended court, but my constituents say they were simply told that the European enforcement order had been ratified and that a charge had been placed on their properties in the UK. They then had to defend the European enforcement order in Cyprus, where they believed they would get less justice than here in the UK. Prior to the first hearing and before they were subject to the European enforcement order, Mr. TC transferred their house into his wife's name to protect her share of their UK property, their only substantial asset. His wife was not party to the property purchase in Cyprus. Following the second hearing, Mr. McNair commented that the judge had not been impressed by the action that Mr. TC had taken. Mr. TC says that he asked for advice on whether or not he should change the title deeds back to his name, and he says all he was told by his solicitor was to let them work for their money, by which he understood him to mean Alpha Bank's British solicitors, Stevenson Harwood. Mr. TC says they always made it clear to their solicitor that their priority was to get the European enforcement order overturned and for no further action to be taken until this was achieved. Over the next few weeks, Mr. TC says much correspondence was exchanged between the two firms, but this did not prevent Stevenson Harwood from continuing to threaten seizure of their properties. However, it did result in regular demands for funds from Cubism Law that they deemed unnecessary. At this stage, they were beginning to be very concerned about the amount of costs that were racking up, and yet the date for the Cyprus hearing, at which they had paid for solicitors in Cyprus to represent them through Cubism Law, was still weeks away and was subsequently postponed 3 times. Mr. TC says he asked his solicitor what the strategy was for their situation, as the costs were spiralling, and all they had asked at this stage was for him to defend the European enforcement order in Cyprus. Mr. TC says that they were also informed, Cubism Law, on the 28th of October 2014, that they did not wish to incur any further costs, but this specific request was ignored and the costs continued to mount. Most of the costs related to the correspondence between Stevenson Harwood and Cubism Law over the transfer of the title deeds. Mr. TC states that if his solicitor had advised him to immediately transfer the title deeds back to his name, he would have done so. He was eventually advised to do this, and for him the question remains why he wasn't asked to do this at an earlier stage. During the time leading up to the hearing dates, Mr. TC says that they were constantly subjected to requests from their solicitor, usually late at night by email, giving them deadlines for payments with which they perceived to be a veiled threat of them prejudicing their case or inferring that they would not be represented in this country or in Cyprus in the future. By this stage, their costs had increased to over £12,000, which was approaching a 5% settlement offer Alpha Bank had alluded to for incomplete properties such as theirs. On the 10th of November 2014, Mr. Gray, they sent an email to their solicitor instructing him again not to incur any further costs, and they also mentioned the 5% settlement figure. This request was again ignored, and he entered into discussions with a barrister, which they were charged for. Mr. TC says they have yet to be informed what the basis of these costs were and what these discussions were trying to achieve. Mr TC says that at no point had they indicated they wished it was not overturned. I will give way. It was not overturned. I will give way.
Listening to this, I just wonder whether, in fact, the constituents of the Honourable Gentleman have taken the matter up with the Law Society and with the Regulation Authority.
Absolutely, and not just my constituents, but myself as the Member of Parliament. Absolutely, and not just my constituents, but myself as the Member of Parliament. And I have to say, Mr Gray, the response that we got back was less than satisfactory. I'm still taking that up with the various authorities, but my constituents feel that one form of redress is to place in the public record the very real injustice that they feel they have endured over the last few years. Now, Mr TC then said that when he pointed out that he had stated that it wasn't possible with the European enforcement order having been overturned, he says that he changed his statement saying that it would be possible, but with difficulty. Now, the new date for the hearing in Cyprus was set for early January 2015. That was then postponed until late January and finally was heard in February this year. I will give way.
This is an issue that I've had people from my constituency with similar problems, not only in Cyprus but also in Turkey as well. I found that the majority of those people are law-abiding citizens who want to invest in property and have it as a holiday home in most cases. But they've found the legal system very difficult. The honourable gentleman is outlining the problems that his constituent has had. Does he feel, as I feel, that perhaps maybe the British consulate could have given advice, better advice or greater advice on what was best to do in a foreign country whenever they don't speak the language and are unaware of the legalities of the system?
Well, I think there's a lot that could have been done differently, and I have some sympathy with what the honourable gentleman says from the experience that I've had, not just in this specific case, but several cases that my constituency office have been dealing with. And I do, again, commend the work of the all-party group and the Minister in trying to bring some kind of resolution to these matters. We are where we are, and it's far from ideal situation. We are where we are, and it's far from ideal situation for many of our constituents. Now, as I said, Mr Gray, the hearing was finally heard in February 2015. In January, though, Mr TC's brother-in-law was out of the country dealing with a family matter, and he told Cubism Law that he had insufficient funds at this time to settle up his latest bill, but would settle at the end of January or early February when his brother-in-law returned to the UK and after the European Enforcement Order court case in Cyprus was settled. Mr TC says Mr McNair replied saying he no longer represented them and again implied that they might not be represented in Cyprus. However, the Cypriot solicitors later assured them that they would be represented. The European Enforcement Order was overturned with reservation at the hearing. Mr TC feels incredibly let down by the representation he received and believes a lot of the costs were avoidable and totally unnecessary. He has complained through the firm's complaints procedures and received what he and his brother-in-law considered to be a derisory offer of redress. They refused and a subsequent offer, and the matter has been referred, as I said, in response to the intervention from the Honourable Member for Stone to the authorities like the Law Society and the Ombudsman. Mr TC feels that he has suffered real injustice in respect of both the property purchase and the way his case has subsequently been handled. I appreciate that there is little that the Minister can do to answer my constituents' specific concerns, but I would be grateful if the Minister could give his time to update the members here today on what progress is being made on this matter in general and what the government is doing to support Mr TC and all of our constituents who are caught up in this sorry situation.
The question is, this House considered the matter of British property owners in Cyprus.